The Supreme Court chamber held its breath as Justice Clarence Thomas interrupted Representative Jasmine Crockett for the 8th time during oral argument. The air was tense, heavy with the kind of silence that follows sustained friction. For nearly half an hour, the verbal tug-of-war had grown more charged with each exchange. Thomas pressing harder, Crockett holding steady. The question before the court involved the reach of congressional power under Section 5 of the 14th Amendment, and the tone between the two had shifted from inquiry to confrontation. "Congresswoman," Thomas said, his voice deep and deliberate, echoing through the marble hall, "you still haven't identified a single constitutional limitation on congressional authority under your interpretation. If Congress alone can decide what qualifies as equal protection, what stops it from rewriting the Constitution's guarantees to match shifting political winds?" Before Crockett could reply, he leaned forward, his expression sharp. "Without firm constitutional limits," he continued, "we risk turning this court into a rubber stamp for legislative will, precisely what the framers feared." A ripple of tension moved through the gallery. Crockett paused at the podium, the faintest reflection of light catching her papers as she gathered her thoughts. When she finally spoke, her tone was calm but deliberate, every syllable measured. "Justice Thomas," she began evenly, "the limitation you seek is already articulated in City of Bourne versus Flores. This court made clear that Congress's enforcement authority under Section 5 must demonstrate congruence and proportionality between the constitutional injury and the legislative remedy. I've cited this standard several times, but I'll be explicit. This statute satisfies that requirement. It addresses violations documented in over 800 pages of testimony and evidence. Persistent state practices undermining the equal protection guarantees recognized in Shelby County. The limit isn't missing, Justice Thomas. It's built into the court's own jurisprudence." The room fell utterly silent. Chief Justice Roberts glanced subtly toward Thomas, whose face betrayed a flicker of surprise. Justice Kagan raised an eyebrow, while Justice Kavanaugh turned to his notes, scanning for citations. The weight of Crockett's response lingered in the air, dense with implication. Representative Jasmine Crockett's journey to this moment had been anything but ordinary. She wasn't known for grandstanding or partisan spectacle, but for the kind of intellectual precision that turned legal debate into performance art. Before entering Congress, she had built a reputation as a formidable constitutional litigator, arguing complex questions of federal power before appellate courts. Her experience, methodical and deeply rooted in doctrine, gave her an unusual edge for a lawmaker and made her uniquely qualified to defend legislation before the Supreme Court. "Constitutional interpretation isn't about power," she once told a campaign audience. "It's about consistency, ensuring the same principles apply across changing times. The Constitution's promises don't bend to politics. They're strengthened by reason." At 42, Crockett carried herself with the same poise she had in the courtroom, a calm intensity sharpened by rigorous preparation. While many colleagues chased cameras, she chased clarity, dissecting constitutional text and precedent with surgical focus. That diligence was what brought her here, arguing a landmark case not as a politician, but as a constitutional advocate. Justice Thomas, in contrast, embodied a philosophy shaped by decades on the bench. Appointed in 1991, he had evolved from the court's quietest member into one of its most probing voices. His questions, once rare, now defined oral arguments, often cutting directly to first principles. A steadfast originalist, Thomas believed the Constitution meant what it did when ratified, that its meaning was fixed, not fluid. "The Constitution means what it meant when adopted," he once wrote. "Our task is to interpret its original, public meaning, not to adjust it to modern sentiments." The collision between these two figures, Crockett's pragmatic textualism and Thomas's rigid originalism, was destined to be electric. The case before them, Alabama versus United States, questioned the constitutionality of the Voting Rights Advancement Act, legislation restoring certain federal oversight of state election laws based on congressional findings of discrimination. As its principal author, Crockett had taken the unusual step of arguing the law herself, rather than deferring to the Solicitor General. The central issue: how far Section 5 of the 14th Amendment allowed Congress to go in defining and remedying constitutional violations. At precisely 10 a.m., Chief Justice Roberts gavelled the court into session. "We'll hear argument this morning in Case 23741, Alabama v. United States," he announced. "Representative Crockett, you may proceed." Crockett approached the lectern with calm precision. "Mr. Chief Justice, and may it please the court," she began. Section 5 of the 14th Amendment grants Congress the authority to enforce the amendment's guarantees through appropriate legislation. The Voting Rights Advancement Act represents a valid exercise of that authority under this court's precedents. Her presentation was structured, logical, and anchored in precedent. For several minutes, she outlined how Congress had documented systemic violations across multiple states, demonstrating that the act met the Bourne standard of congruence and proportionality. Justice Barrett asked the first question. "Representative Crockett," she said, "how does this differ from the coverage formula struck down in Shelby County? Isn't this essentially a new version of preclearance?" "The distinction," Crockett replied, "lies in the foundation. Shelby County invalidated an outdated coverage formula, not the concept of preclearance itself. This statute relies on current data, reflecting violations from the last 25 years, not the 1960s. The court objected to stale evidence, not congressional oversight. "We corrected that," Justice Kagan followed. "And what about tailoring? How do these provisions ensure the remedy matches the violations?" "The Act calibrates oversight according to the scope of violations," Crockett answered. "It creates 3 levels of review, the strictest reserved for jurisdictions with the most persistent violations. This ensures proportionality under Bourne." Her responses were concise, methodical, and grounded in doctrine. "But it was Justice Thomas who disrupted the rhythm." His voice carried through the chamber, low and deliberate. "Representative Crockett, your interpretation gives Congress vast discretion to determine what equal protection means. Where is the limiting principle?" "Justice Thomas," Crockett began, "the limitation—" He cut her off sharply. "If Congress can decide the meaning of equal protection, then what remains for this court? Either Congress defines constitutional guarantees, or we do." The courtroom felt smaller suddenly, the air thick. Crockett remained composed. "Both branches play distinct roles, Justice Thomas. Congress identifies violations through its superior fact-finding ability. The court ensures the legislation stays within constitutional bounds. It's a dialogue, not a hierarchy." Thomas leaned back, unimpressed. "That sounds like a distinction without substance. Congress could still reshape constitutional meaning under the guise of enforcement." Crockett didn't flinch. "Congress cannot redefine rights, only enforce them," she replied. "Its Section 5 authority is remedial, not substantive. South Carolina v. Katzenbach recognized Congress's competence to determine remedies for constitutional violations without changing what the Constitution means." "Katzenbach," Thomas interjected, "involved the 15th Amendment, not the 14th. The standards differ." "True," Crockett acknowledged, "but Bourne v. Flores directly addressed the 14th Amendment and clarified that Congress can prevent or remedy violations, not alter the underlying meaning. This legislation stays within those boundaries." Thomas's tone hardened. "Even under Bourne, this act appears to redefine equal protection through its coverage formula. It imposes broad federal control based on Congress's own assessment of discrimination." "The formula," Crockett countered, "targets jurisdictions with patterns of violations already recognized by this court. Cases like Cooper v. Harris and League of United Latin American Citizens v. Perry. Congress isn't inventing rights, it's enforcing those you've defined." The exchange escalated. A rhythm of question, interruption, response. By the 5th interruption, Thomas's skepticism had turned visible, his tone almost accusatory. "That still leaves Congress deciding what counts as a violation," he pressed. "That's constitutional interpretation, not enforcement." "There's a difference," Crockett replied firmly. Congress applies this court's definitions to factual realities. Identifying violations doesn't redefine the law. It enforces it. The court remains the arbiter of constitutional meaning. Thomas wasn't convinced. That distinction collapses under scrutiny, he said. Fact-finding is itself interpretive. Crockett's voice sharpened slightly. Then the safeguard lies with this court's review, she replied. If congressional evidence is insufficient, Bourne provides the corrective mechanism. Here the record is extensive. 850 pages of documented violations aligning with this court's equal protection jurisprudence. By the seventh interruption, Thomas's patience thinned. This statute establishes an entire regulatory framework far beyond the violations you've cited, he said. That's legislative overreach. The remedies are tailored, Crockett insisted. 3 tiers of oversight, each proportional to the severity of violations. That's the very definition of Bourne compliance. Then came the 8th interruption, the one that froze the room. Congresswoman, Thomas said, leaning forward, his voice booming, you still haven't offered a single limiting principle. If Congress can determine the scope of equal protection, what stops it from rewriting constitutional meaning as political majorities change? Without clear boundaries, this court becomes an echo chamber for legislative will. He paused, eyes fixed on her. That is precisely what the framers sought to prevent. The air seemed to pulse with silence. Crockett exhaled quietly and raised her gaze. When she finally spoke, it was not defensive, but grounded, her tone steady as marble. Justice Thomas, the limit is Bourne versus Flores. This court itself imposed it. Congress's authority must be congruent and proportional to the constitutional harm identified. This statute is both. It remedies proven violations, supported by exhaustive evidence, not political will. The limitation exists because this court placed it there. No one moved. The stillness that followed carried the rare weight of intellectual equilibrium, the moment when argument becomes revelation. Even Thomas, usually impassive, blinked once, expression softened by something that resembled acknowledgement. For the first time that morning, he didn't interrupt. The silence that followed Jasmine Crockett's final statement seemed to expand through the courtroom, absorbing every whisper, every faint shuffle of papers. For a long moment no justice spoke. Even the sound of pens against legal pads ceased. Justice Sotomayor leaned forward slightly, a quiet nod almost imperceptible, as if to acknowledge the precision of what had just been said. Across the bench, Justice Kavanaugh shifted in his seat, his expression measured. Chief Justice Roberts cleared his throat softly, the kind of neutral sound that signaled both transition and relief. "Thank you, Representative Crockett," he said. "Justice Thomas, do you have any further questions?" Thomas hesitated. For once, his gaze was not the sharp, challenging stare that often disarmed counsel. It was contemplative, even introspective. He turned a page in his notes, but didn't speak. After a moment, he set the pen down and said quietly, "No further questions, Mr. Chief Justice." A rustle passed through the gallery, a subtle collective exhale. Crockett inclined her head respectfully, turned a page in her binder, and continued. "Mr. Chief Justice," she resumed, her tone even but resolute, "Congress has acted here not to create new rights, but to preserve existing ones. Section 5 empowers Congress to enforce the guarantees this court has already recognized. To retreat from that understanding would be to render Section 5 an empty vessel, one that holds no power to protect the very liberties the 14th Amendment was designed to secure." Her words resonated in the chamber like a deliberate echo of constitutional purpose. Every phrase drew from history, from the post-Civil War Congress that drafted the Reconstruction Amendments, and from the decades of case law that followed. The framers of the 14th Amendment, she continued, did not envision a passive Congress. They wrote Section 5 precisely because the judiciary cannot always foresee or prevent violations of constitutional rights at the state level. The enforcement power was their remedy, the mechanism to ensure that constitutional guarantees lived beyond the parchment. Justice Alito interjected, his tone cautious but probing. "Representative Crockett, You speak of living enforcement, but doesn't that invite the very problem Justice Thomas raises? How do we prevent that living enforcement from becoming living amendment? Crockett nodded slightly. That is the essential question, Justice Alito. The answer lies in judicial oversight. Congress investigates and legislates. This court reviews and constrains. The tension is not a flaw, it's a safeguard. It keeps both branches in conversation rather than in competition. Chief Justice Roberts leaned forward. So your view is that Section 5 authority functions within a dynamic framework, one that adjusts as factual patterns evolve, but not constitutional meaning? Precisely, Mr. Chief Justice, Crockett said. The Constitution's text is fixed, but its application must respond to reality. Otherwise, equal protection becomes a relic instead of a right. Roberts nodded thoughtfully, his fingers tapping once against the bench, a sign he'd found her framing difficult to dismiss. Justice Ketanji Brown Jackson broke the silence next. Representative Crockett, what you're articulating aligns with the Reconstruction, Congress's own understanding of Section 5, that it wasn't merely a procedural safeguard but a substantive guarantee that the federal government would intervene where the states failed to protect equal rights. Crockett turned toward her. Exactly, Justice Jackson. The Reconstruction debates show Congress understood Section 5 as an active tool, not a passive one. It was the federal government's promise to enforce equality in the face of state resistance. This act honors that legacy. A murmur ran through the back rows of the gallery. Legal scholars, reporters, and aides exchanging glances. They knew the gravity of this moment. This was not just an argument about voting rights. It was about the architecture of American federalism itself. Thomas sat quietly now, his expression distant but reflective. The earlier tension in his posture had eased. He was listening, truly listening, in a way that those who followed his long judicial career rarely witnessed during oral argument. When Crockett concluded her allotted time, she closed her binder and said, "Unless the court has further questions, I reserve the remainder of my time." Roberts nodded. "Thank you, Representative Crockett." As she stepped back from the lectern, the Solicitor General rose to argue in support. But it was clear to everyone present that the day's defining exchange had already taken place. The clash between Clarence Thomas and Jasmine Crockett, a collision of constitutional philosophies that transcended personal rivalry. Outside the court, the reaction was immediate. News networks replayed the confrontation in endless loops. Pundits dissected every inflection, every pause, every citation. On social media, clips of Crockett's steady, unflinching delivery spread with captions like, "The moment she made Clarence Thomas pause." But inside the marble walls, the aftermath was more subdued, a quiet reckoning among the justices themselves. 2 weeks later, the court's opinion in Alabama versus United States was released on a bright Monday morning. The decision, 6-3, upheld the Voting Rights Advancement Act as a valid exercise of Congress's enforcement power under Section 5 of the 14th Amendment. Chief Justice Roberts authored the majority opinion, joined by Kagan, Sotomayor, Jackson, and, in a subtle but symbolically seismic move, Justice Kavanaugh. The majority's reasoning was meticulous. It acknowledged the Bourne Standard, reaffirming that Congress's enforcement authority must remain congruent and proportional to documented constitutional violations. The opinion cited extensive legislative findings and emphasized that Congress had acted based on recent and substantiated evidence. "The act before us," Roberts wrote, "is neither an expansion of constitutional meaning nor a circumvention of judicial authority. It is an exercise of Congress's duty to preserve constitutional guarantees in light of contemporary evidence. Section 5 does not freeze the understanding of enforcement in the 19th century. It ensures that constitutional promises retain their vitality in the 21st. Justice Thomas, joined by Justices Alito and Barrett, dissented. His opinion was forceful, characteristically grounded in originalist reasoning. "In my view," Thomas wrote, "Section 5 does not grant Congress the power to define constitutional violations, only to remedy those already identified by this court. Today's decision risks eroding that boundary and invites a future where legislative determinations overshadow judicial interpretation. Yet, even within his dissent, observers noted an unusual restraint. Gone was the sharp personal tone that sometimes colored his oral questioning. Instead, his words carried a note of wary respect, an acknowledgement, perhaps, that the debate itself had deepened his own reflections. In the days that followed, the legal community dissected the ruling. Some hailed it as a long overdue restoration of congressional authority under the Reconstruction Amendments. Others warned it could open the door to legislative overreach. But few disagreed on one point. Representative Jasmine Crockett had changed the tone of the national conversation about constitutional power. Her closing argument, quoted in editorials and law reviews alike, became emblematic of a new generation of constitutional reasoning, one that married historical fidelity with pragmatic enforcement. Enforcement, she had said, is not invention, it is preservation through vigilance. That line found its way into classroom discussions, judicial symposia, even floor debates in Congress. It encapsulated what her performance before the court represented, a reclamation of the Constitution's moral intent from the confines of static interpretation. Weeks later, Crockett stood in her congressional office overlooking the Capitol dome. The light of late afternoon slanted across her desk, illuminating the stack of handwritten letters that had poured in since the decision. Some were from law students who had watched her argument in awe. Others were from ordinary citizens thanking her for defending their right to vote. She opened one envelope, its neat cursive betraying an older hand. "Dear Representative Crockett, I'm 82 years old. I marched in Selma. I never thought I'd live to see someone stand in the Supreme Court and say what you said, that our rights are worth enforcing, not just remembering. Thank you." She folded the letter carefully and placed it in a drawer beside a framed photograph. Thurgood Marshall standing on the steps of the Supreme Court. It had been her father's, given to her when she graduated law school. Outside, the city buzzed, horns, sirens, the low hum of power in motion. But inside her office there was quiet. She exhaled and allowed herself a moment of reflection. For all the grandeur of the court, the real battle had always been the same: convincing the nation that equality required action, not nostalgia. The Constitution, in her view, was not self-executing. It lived only through the courage of those willing to defend it, not with slogans, but with argument. Across town, in his chambers, Justice Clarence Thomas sat at his desk surrounded by stacks of law reviews and case digests. The dissenting opinion lay open before him, annotated in his own handwriting. He read the words he had written. "Congress's role is remedial, not interpretive," and then looked toward the window where the afternoon light had faded into dusk. For a moment, he thought back to the argument. The way Crockett had spoken of the Constitution's endurance, not as revision, but as responsibility. He didn't agree with her, not fully, but he respected her precision, her command of history, her refusal to yield to rhetorical traps. It reminded him of something rare: the power of genuine conviction, unvarnished by performance. He closed the file, turned off his lamp, and for the first time in years, lingered a moment before leaving the chamber. Not in frustration, but in contemplation. Months later, law students at Georgetown University gathered for a symposium titled "The Future of Section 5: Lessons from Alabama versus United States." On the panel sat constitutional scholars, former clerks, and Representative Jasmine Crockett herself. One student asked, "Do you think the decision changed Justice Thomas's view?" Crockett smiled faintly. "The point of argument isn't always to change a mind," she said. "Sometimes it's to clarify the stakes. He and I disagree on interpretation, but we share a belief that the Constitution deserves seriousness. That's enough." A pause settled over the auditorium, the kind that precedes understanding. Then the room erupted in quiet applause. Later, as she walked out into the evening air, Crockett looked up at the faint outline of the Capitol dome glowing against the twilight. History, she thought, never moves in a straight line. It bends, resists, and sometimes surprises. But when pressed with reason and courage, it advances. And somewhere, deep within the archives of the Supreme Court, the official transcript preserved the moment when a justice long known for his certitude and a congresswoman known for her resolve met on the field of constitutional meaning, and left, not as victors or adversaries, but as participants in the endless, necessary dialogue that keeps the Constitution alive.